Hi, my name is Amanda Rocha. I am an estate planning and probate attorney in California, and today I am going to answer the question, is your inheritance community property? Before I get into that, I want to give you my contact information. You can find me on my website at www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or follow along on social media. You can find me at Amanda Rocha Law. So the reason I am going to talk to you today about whether inheritance is community property is because I have an existing client who is a probate client actually, and recently asked me, listen, this inheritance that I'm going to be receiving after probate, am I going to have to worry about that inheritance if I get a divorce or, if I pass away, what will happen? And in this scenario, this person is actually married with children from his married spouse. But there are different ways in which this inheritance can be split up going forward in the future. So I'm going to cover most of these scenarios for you. So number one, is an inheritance community property immediately? And if you are an internet fan, you'll know immediately no is my answer. No, immediately. If you inherit, let's say $100,000 tomorrow and you're married, it will not immediately become community property. The only way that it will immediately be joint with someone else is if the trust or whatever instrument it is that is dictating your inheritance gives it to both you and your partner, in which case it's still not community property. It just means that you get half and your partner gets half of whatever was given to the two of you. So let's just say the inheritance is in your name only. It will not be community property in nature right away. It can turn into community property though. So if you receive a sum of money and you commingle those funds with your spouse's funds or your community fund. So let's say you have a joint account and it's a smaller sum of money, maybe it's $10,000, and you put it into your joint account and you just start spending as normal, then you're commingling the funds and you're not keeping it separate in any way. And if you haven't signed any documents with your spouse or made any agreements stating that this money is still separate, it's going to be considered community property at that point. However, if you put that into an account that is your name only, it will remain separate property throughout your lifetime as long as you have it. Any interest you gain on that money is still going to be separate property. If you gift it to your spouse, however, that's a completely different story. Then you're getting rid of it. Its nature of being separate property. Now, if you get divorced and you have this money in a separate account or traceable, a way that you can trace back into your account saying, okay, we knew that this $30,000 is just going to sit here and we weren't going to touch it and we haven't dipped below, that kind of thing, then it will remain separate property at your divorce. However, if you pass away, some of that separate property might go to your spouse and some of it could go to your children. It depends on whether your children are from your spouse. If you have children outside of your marriage, they will receive a different percentage than what your children within your marriage would receive. And if you have a combination, it's a whole different ball game. But for the purposes of this video and for my client, anything that you inherit and you keep separate will remain separate no matter how long you've been married. If you have questions about this, please feel free to contact me. You can find me on my website at www.amandarocalaw.com. You can comment down below or follow along on social media at Amanda Rocha Law. Thank you.